proof evident presumption great. I know that the state is relying on the transcript, which Your Honors had an opportunity to review. There was a hearing approximately 51 weeks ago. There have been change of circumstances, which I'll outline for the court, we believe, over the course of the last, let's say, approximately 1 year. And I would say it's somewhat ironic. We've heard testimony about our client going into custody in 2019 at 19 years old. The irony is that tomorrow this young man turns 27 years old, and he's been in custody since 19 without ever having been found guilty of a single offense, with one indictment having already been voluntarily non-prosecuted by the state. But we find ourselves here, and I want to address proof evident presumption great. And the first thing I want to talk about is one of the change of circumstances is that Judge Murphy's granting of the motion to suppress has been affirmed by the Court of Appeals. And it's worth noting that not only was it affirmed, but no good faith exception even applied. And the gist of that affirmative finding and the underlying motion to suppress goes to the credibility of Detective Moretti. And we spent a lot of time studying this trial and studying the transcripts, and of course we had the unique opportunity to see YouTubes of a trial. That's a rarity. And it's fair to say that two things take place. One, as was discussed earlier today, so much of this case was about a hearsay statement by Cortland Henry. But this case was navigated by the field general, that being Detective Moretti. Detective Moretti, who was the subject of the affidavit, was found to, his credibility was called into question in the granting of the motion to suppress and ultimately the Court of Appeals position. And so to us, that's really important because it actually, we know that the court, we're aware of the court having found proof evident presumption great a year ago, but in light of his credibility into being called into question, we are strongly arguing that the court think about the chiseling away of his credibility, the chiseling away of his believability, not to his investigation itself, but just to the issue of credibility, because as the court is well aware, credibility and even impeachment are what generate, through instructions to a jury, etc., what it generate reasonable doubt. But for your purposes, what chisel away at proof evident presumption great. And stepping in and looking at this, I think it's essential, and we think it's essential, that the court look again at the issue that involved the July 27th, 2023 interview of Michelle Boutros regarding a statement that took place October 12th, 2022. Understanding that the defense team that tried that case, the transcript as reflected that Your Honor reviewed, did not have the benefit of that knowledge. We have studied the examination of particularly Mr. Adelstein, who spent what appeared to be hours and hours cross-examining Detective Moretti without the benefit of understanding and knowing and having been given that information, and we know how that impacted the state attorney's office, but what happened on October 12th, 2022. And of course, as the court is well aware, that involves Assistant State Attorney Michelle Boutros, and it doesn't escape me that she was with the Public Integrity Unit at the time. Revisiting that for a second, as the court knows, at the state attorney's office in this building, there was a service of an interview and a search warrant on Jamie King, and at that time, because he was outside of his jurisdiction from the city of Miramar, he needed to have somebody from Broward County Sheriff's Department there. He did not, and so what transpires according to, and I just want to say for a second, as a career criminal defense attorney, with great respect to people that do crimes, major crimes, prosecutors that specialize in homicide, prosecutors that specialize in crimes against women and children. As a defense attorney, our most difficult cases are dealing with the public integrity unit prosecutors. They are what we call sometimes the truth prosecutors, right? They protect the thin blue line between corrupt law enforcement, overly violent law enforcement, and the community. They're the ones that handle corruption, political corruption. They protect the community from corrupt public officials and public employees. Personally, I have been dealing with public integrity unit prosecutors I have incredible respect for, from my representation of law enforcement officers to elected public officials at the highest level. And they consider themselves to be the integrity, the truth prosecutors. So the fact that this involved somebody from a public integrity unit speaks very strongly to the defense on behalf of Mr. Demons. And so to have Ms. Boutros say that she was in a room with the lead detective in this case, Detective Moretti, and the defense tried this case, and Mr. Adelstein do his cross-examinations and not know that she made a statement that in that meeting in 2022, Detective Moretti said to a deputy from Broward County Sheriff's Department, "You need to say you were here when I served the search warrant." For her to say, "I immediately reported this to my supervisor," to her to say, I won't work with Moretti anymore, I would not have anything to do with investigating with him. For somebody from the state's attorney's office, and I'll give you that transcript if Your Honor doesn't have it.
And Judge, if I may, I'm just going to object at this point. None of this was presented in evidence, so I'm confused on how we're now bringing this up in argument.
It's just his argument.
And for her to say, you don't have, thank you, Your Honor, you don't ask another law enforcement officer to lie for you as a joke, and I wouldn't work with him anymore, and the case was given back to the then trial attorney, Christine Bradley. Why is that important? Well, it's important because in the transcript, Your Honor, there are numerous times when Your Honor is reading that transcript and taking into consideration whether or not proof is evident and presumption is great, you have to think respectfully about what was lacking. At the crescendo of Mr. Adelstein's lengthy cross-examination of Detective Moretti, on July 17th in the transcript, on page 95, line 3, he talks about lying could result, talking about witnesses in his cross-examination, lying could result in somebody being charged with a crime. Page 95, line 17, not being truthful could result in being arrested, talking about accessory after the fact. But again, Moretti addressing the issue of lying. All this without Mr. Adelstein having the ability to impeach and thoroughly and siftingly cross-examine Moretti about the fact that he was requesting another law enforcement officer to lie. Armed with that ability to cross-examine in front of a jury that was unable to even reach a verdict in this case is something that the court should take into consideration as we chisel away by the original finding. He says this similar statement again, lying could result in being charged at page 96, line 17, page 98, line 8, lying could result in their arrest. And so the credibility of Detective Moretti, this is the lead detective. This is a case, again, as the court noted, that is basically relying on a hearsay statement by someone whose case was ultimately dismissed with a jury that couldn't reach a verdict, and a detective who is literally the summary witness. He is bringing it home, not just summary witness interviewing records, but bringing home all types of issues regarding his opinion and marshaling evidence and rendering opinion after opinion. On that same date of July 17, 2023, in one of the most important parts of the cross-examination by Mr. Adelstein of Detective Moretti, he hits him with a crucial issue, which is you did not seek a search warrant on or about October 26th or in the weeks afterwards regarding the one place that you should have sought a search warrant, the most obvious place possible, which is the residence of all 8 people that were at the studio the night this happened, including Cortland Henry, including Mr. Demons, including the 2 decedents, and then 4 other witnesses. Mr. Adelstein, as he should have, cross-examined the detective. Tell me about your search warrant. I didn't get one because I didn't have a nexus. I made sure I called Ms. Howard to find out whether Florida was different than the rest of the United States, where we look at probable cause. When a detective talks to a prosecutor and talks about probable cause, the bottom line is Detective Moretti dropped the ball. He went after the shiny objects, which resulted in this massive suppression of phones and Twitter accounts and all these little shiny things, but didn't look to the one place where your decedents and your defendants were residing. And his answer was, I didn't have nexus. Well, if he had been armed with the fact that this detective did the most egregious thing that a detective can do, the most egregious thing, and that is request that another officer lie and get called out by a prosecutor. If he had been armed with that information, if the defense had had the ability to even not only impeach, but to call Ms. Boudreaux, because they could have done that, it could have been a very, very different transcript. And I think it's important that the court take that into consideration. The state attorney, Broward County State Attorney, makes their decision on how to move forward. They made a decision after 2022 to go with a detective as a lead detective in a case that requested another officer to lie and cast aside the opinion and the philosophical and ethical beliefs of one of their public integrity prosecutors. That's something they have to live with, and obviously there's been a change of guard because of that type of behavior. But it is something that the defense was denied. So when you read that transcript, I saw before in the previous hearing before we were involved that your Honor said, and I appreciate it, that I believe you said I could do a Franks versus Delaware analysis on this. I think that was your quote from what I've read, and I think that's a great way to do that. And so we would ask the court, when you re-review whatever you re-review, to take these things into consideration. And there's just numerous other examples of where Detective Moretti could have been cross-examined and impeached based on the fact that he has requested somebody to lie. That goes to his veracity. More importantly, that goes to his credibility, which generates reasonable doubt. When Mr. Adelstein cross-examined him, going through at the tail end of his, in the beginning part of his cross, he went through all the places that he passed and asked if he looked at security videos. And then he said, I didn't do this one and that one. And then on redirect, he said, well, in a question by Ms. Bradley, most of them, like CVS and Walmart, focus on what's going on inside a store. I will tell you something. Your premises liability lawyers and the limited work I've done, that is just an untrue statement. That's just an untrue statement, and Detective Moretti, I'm sure, knows better than that stores are concerned about their parking lot security and cameras are facing out all the time. But again, Mr. Adelstein didn't have the fact that Detective Moretti was somebody that seeks not a citizen, but a fellow officer to lie. And I've defended officers, probably more than most, on violation of oath cases, and they're pretty tough to defend. Your Honor, some other issues to take into consideration, and that is what is different between now and then from your last time you reviewed this 51 weeks ago, is that Cortland Henry, who was charged as a co-defendant in this case and charged with murder in the first degree with the use of a firearm in counts 1 and 2. Cortland Henry, who the state in that first transcript believed was lying from the first trial, who the state went out of their way to show that he had gunshot residue, he had GSR on his hand. The state went out of their way to show that he had DNA on his clothing, that the state dismissed those murder charges. We don't know. All we know what's in that transcript. That transcript, the court made some observations at the beginning of the day We don't know from what his statement is. All we know is what he gave, but what we do know is that at that time he was charged with murder. For whatever reason, given all this, the state's assessment of this case is that his case, without any cooperation, was worthy of a dismissal. And that should speak volumes to the court when the court is assessing proof evident, presumption great. Because there's really nothing in the record that the court could look at. Nothing evidentiary in the volumes that you've looked at to distinguish these two individuals, Mr. Henry or Mr. Demons. And so that's yet another thing to take into consideration. To the extent that the court has looked at the tampering case a year ago, because a year ago that case existed, to the extent that that was something that the court was contemplative about. Your Honor knows that we got in this case, I believe, last August, and Ms. Howitt and I, from the very, very beginning, were absolutely committed to trying that case. There was no attempt for us to continue the case. As the court noted, we came into the case, filed a series of motions. Quite frankly, from a defense perspective, there wasn't a lot done on the case. We really weren't clear which of the attorneys was actually in the case and who were not in the case. But we came in and not wanting to continue anything, trying to handle things with efficiency and promptness, filed our motions, ready to go. We laughed yesterday as we prepped for today about we have text messages and phone calls on Christmas Eve. We were in communication through the holidays. Your Honor was kind enough to have 250 jurors ready. I believe you said you had 250 backup. The day before that trial, the case was dismissed with what we thought was without explanation. And then, of course, as we noted in our motion for bond, in our footnote 1 or 2, the state issued a statement about not wanting to wait for a ruling by the court. That's just unacceptable. And the bottom line is that the state didn't give Mr. Demons the ability to get his not guilty verdict. Because I'll say right now, that would have been a 30-minute not guilty verdict. It would have taken 25 minutes to choose a foreperson and 5 minutes to deliberate, and he's found not guilty in that case. So he was denied that opportunity to get his not guilty. So when we look at the first issue of proof evident, presumption great, and I know these are issues that the court is very aware of, and it's interesting, and Your Honor, I think pro hoc vici is not a right, but it's a privilege, and I appreciate that privilege, and I'm trying to do everything I can to understand, because things are different when you travel around, but some things are not different. So here's what's not different when we use this incredibly high standard in the state of Florida, which is beyond guilt and reasonable doubt, and that is that this is a case that a jury was not able to render a verdict. One, this is a case with no DNA implicating Mr. Demons. Two, this is a case with no fingerprints implicating Mr. Demons. Three, this is a case with no surveillance showing that he had anything to do with being in a vehicle or, more importantly, shooting anybody. Four, this is a case with no eyewitnesses whatsoever. Five, this is a case where we have a detective, the lead detective that ties the bow and brings it home at the end, that is asking another officer to lie. Your Honor, I'm not one of those lawyers that says at night, you know, God, what a crappy profession. I hate it. I love being a lawyer. My history is full. That's how Ms. Howitt and I are friends. We're not friends from trying cases. We never tried a case together. We have both been committed our whole careers to bar associations and teaching young lawyers. That's the foundation of our friendship. So we're both lawyers that are honored to be lawyers and respect the other side. Respect, you'll never hear me condemning prosecutors, and I always will jump at the opportunity to represent somebody in blue because our society needs them. But here's what we don't need. We don't need a lead detective pinned up against a public integrity prosecutor and right in front of her trying to get another officer to lie. That casts doubt on everything that Moretti does, everything that he touches. And I will be the first person to be shocked if he stays lead detective in this case. We've all done cases where somebody, for whatever reason, is removed from a case and a new person comes in and picks up what they did. But hey, if this case goes to trial, bring him on, because he's a liar. And so then we have ultimately the motion to suppress that is affirmed by the Court of Appeals, which casts doubt again on his credibility. And so when Your Honor does the proof evident presumption, great. I ask you to take all of these into consideration, and of course what we talked about earlier, and the fact that a co-defendant who, if you read the indictment, is side by side culpability wise, that case is dismissed. And I just would argue to the court that all of those just chisel away at the court's previous finding of a year ago. And so unless the court wants me to do otherwise, I'll hold off on the second part of the argument until after the state goes. You do the whole thing? Okay, thank you.
That's everything in proof evidence?
Yes, sir.
Okay.
Yes, sir.
And then if I exercise discretion, or if I agree with you and I find the circumstances have changed, I don't find proof evidence presumption great, it's exactly what you want me to do.
Yep, I will. Thank you. Give me 1 second. Your Honor, in looking at your statutes and looking at your law, I ask you to exercise that discretion and set a reasonable bond. And I'm going to talk in a second about the conditions of release that can be reasonable. And I first want to talk about protecting the community from risk of physical harm. There was nothing presented in the case regarding Mr. Demons that in any way involves his threat to the community. And most important to me is when we talk about this second process is assuring the integrity of the judicial process. So I want to talk about the conditions of release that we would suggest. First, I want the court to think about the testimony that we just heard from Matthew Norman, a distinguished forensic psychiatrist that honestly, you heard he's from Georgia. I've really been more against him than with him. We've had some battles through the years, and he's an incredibly ethical and devoted to this issue and all forensic issues regarding mental health. It's worthy of note to me that the state had no cross-examination. And in like fashion, I know that last year there was, I think at the hearing they were going to offer somebody and they served notice like the day before, and we would never do that. We served notice in plenty of time, and I'm sure that that's something the state looked into. But here's what I'm also sure of, just like there was no cross-examination. There's not a mental health expert in America that would agree that these conditions that we heard about are healthy for somebody that went into custody at 19. There's no need to cross-examine because there's nothing to ask, because it's irrefutable what we heard. It's irrefutable. It's irrefutable that 27% of Mr. Demons' life has been incarcerated without having been found guilty of a single offense. If we look at him from the time he was turned majority in the state of Florida, 18, 30.5% of his life has been incarcerated. I've looked into the cognitive state, begins, they say, at 3 years old.